Hello, this is Matt on the Moon Lambeau channel. An SEC attorney in their case against Ripple has lied in an attempt to manipulate the court. I'm going to share with you in this video opinions from a pro-XRP attorney highlighting the specifics of this, and I want to make clear the implications of all this. If the SEC gets their way, there could be dire consequences. Did you know that back in the day, there was actually a push to require certification to have internet access? Yeah, it's pretty wild. And just imagine if that's what had unfolded instead of having free open access without the government being some sort of ridiculous gatekeeper. What would it be today? And so there's no less than that at stake today with crypto. But and it's actually potentially even worse because if you find that the internet, that's the internet of information, yeah, that'd be bad if you don't have access to basically the sum of all human knowledge. But perhaps this would be even worse because you're talking about the flow of money globally. Perhaps bigger ramifications if this actually goes off the rails. Not that I'm fully anticipating it to. I do think that what is just shall be done, but there's no guarantee. There is risk here. Now, at the outset, I do want to be clear that I don't have a legal or financial background of any kind. I am not offering financial advice. And you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who makes YouTube videos as a fun hobby. That's all that's going on here. Nothing special about me. But the attorney that I'm talking about here is none other than John Deaton, and I always want to prop up those that are contributing to the XRP community in meaningful ways, so I would like to encourage you to follow John Deaton on Twitter if you've not yet done so. His handle is at his first name, John, J-O-H-N, then his middle initial, the letter E, then his last name, Deaton, which is D-E-A-T-O-N, and then the number 1. Go ahead and follow this man. You will not regret it. In fact, if you're not on Twitter, I don't blame you. I was not on Twitter for the vast majority of my life because I knew it was a cesspool. I had seen and heard enough about it. But I joined anyway because I found out that there were a bunch of people into XRP on it, and I don't regret it. I just blocked out all the rest of the noise. You can block anyone you don't want to listen to. And I'm certainly better for it. I wouldn't know half of what I know about XRP, and I wouldn't have gained all these friends had I not taken the plunge. So if you've not jumped on Twitter, even if you hate Twitter and it's stupid, I mean, it is stupid, but you might want to consider giving it a go. You might not regret it. So there we go. But here's what John Deaton had to say. XRP and exchanges. I hope to be proven wrong, but as I've said before, I do not believe that Coinbase, Kraken, Binance, etc. are going to relist or unsuspend XRP until the SEC comes out and issues a no-action declaration or we get clarity from the Southern District New York Court. And so I'll pause there and just share that that's exactly what I've been thinking this whole time, because even if it's the case that from a legal perspective they should be in the clear, that doesn't mean that somebody couldn't come after them and sue them. But even saying that, as you'll see here throughout as I go through these comments from John Deaton, it's perhaps not the case that exchanges are in the clear. In fact, and I meant to mention this in the intro too, you listening to this, if you're trading XRP specifically, and ultimately I think any other crypto, you could be accused of actually transacting a security, as you'll see here. So despite what the SEC has tried to say, as far as, it's only Ripple and Ripple employees that they're going after here, not so fast. So let me continue with the thoughts here from John Deaton. Let me explain how the SEC attorney misled the court when answering Judge Netburn's question regarding whether anyone selling XRP would be violating Section 5 of the Securities Act. This will also help me prepare for our brief, which is due in 8 days. And so the SEC attorney, his name is Jorge Tenrero, and John writes as follows. Attorney Tenrero said that Section 4 exemptions would apply, and therefore retail holders would not be in violation. Not true. If the purpose and intent is to have XRP distributed by purchasers into a secondary market, no exemption applies under Section 4, as Tenrero suggested to Magistrate Netburn. And so, to be clear, Magistrate Netburn, that is Judge Sarah Netburn, one of the judges in the case here. And then John continues. The Telegram case tells us all we need to know. Judge Castell found that Telegram's offers and sales of the grams, so that'd be the token for Telegram, grams, represented an ongoing violation of Section 5 and must be enjoined before reaching public distribution. So basically, if the digital asset gram or XRP is going to end up being sold to the public, Section 4 exemptions do not apply. This isn't my interpretation. Let me quote the judge. And here's the quote. When distribution reaches the public, the SEC can invoke jurisdiction and claim that the public needs the protection of the Securities Act. End quote. So, the exchanges would not have an exemption. If you or I intended to sell our XRP, we wouldn't be exempt because we could be called an issuer because, as Judge Castell wrote, quote, the term issuer means every person who issues or proposes to issue any security, end quote. So think about that. If you're selling XRP, you could be legally considered an issuer of XRP, and the government could come after you. Now, there's so many people, I don't think they're going to come after everyone, so even if it's not you specifically, but it wouldn't matter. It would shut everything down. So even if there weren't legal ramifications for you listening specifically, technically you'd be liable for any sort of activity that they deem you did illegally, even if they don't go after you. But beyond that, who's going to trade XRP in the United States? Like, it would effectively push all of the activity and all the innovation outside of the United States. Who knows what that would mean for Ripple? I certainly anticipate that they wouldn't remain in the United States, and if they were gonna conduct any business in the United States utilizing on-demand liquidity, XRP could not be a piece of it. They'd have to use a different cryptocurrency for any corridor that touches the United States. It would just be a complete train wreck. And so this, the approach that the SEC is taking here, it's draconian. It's illogical too. That's why, to me, I keep saying, as far as like, why are they doing this? We can only theorize, but it just seems like a power grab and a money grab, unless there's some sort of other underlying dynamics on a personal level that we're just unaware of, which certainly could be the case. Beyond that, what the hell is going on here? It just doesn't make any logical sense. Now, John continues. Just in case some of you don't believe I'm correct and don't believe issuer could mean anyone, here is what Attorney Solomon said to Judge Netburn after Tenrero said what he said. And by the way, Attorney Solomon, that's an attorney for, I think it might specifically just be for Brad Garlinghouse. Maybe he's with Ripple. I actually can't recall off the top of my head, but he's on side Ripple regardless, whatever. That's all you need to know for this, for the purposes of this video. And so here's a quote from Attorney Solomon. So in theory, Judge, each domestic sale could be a violation, and that would include, contrary to what Mr. Tenrero said, not just Ripple's affiliates, but any retail holder or any party if there is any intent to distribute the security further. And so there you go. Attorney Solomon is calling out the SEC attorney Jorge Tenrero for the lie. Like, that's a lie. You know, this is a lie that has been stated. Now, because if it's not a lie, so here's the thing: for something to be a lie, something has to be said that's not true, but that's not the full standard for it. The litmus test continues. If something's a lie, it must be knowingly said by whoever said it must know that it is not true. So if this guy's just if SEC attorney Tenrero is just a really bad attorney and clueless, then he could say something that's not true that isn't a lie. But if he is aware that what he is saying is true, and how the hell could he not, if he knows that it's not true, that is a lie. That is an out lie. And John continues now. Hence, the exchanges are not exempt under Section 4. Hell, we aren't exempt under Section 4. This case is bigger than many realize. I will be thrilled to be wrong if one of the exchanges that delisted or suspended XRP found the courage to begin trading it again. I hope they all do. But our fight is in the Southern District New York Court. I just wish the other cryptos realize that Ripple and XRP holders are fighting for all. Oh yes, it's bigger than just Ripple. It's for all of crypto ultimately. This is going to have impacts on everything. And I'm like John too. I've said this before, but I want to be super clear on this. I want exchanges, all of them, to relist XRP. I think it's horrible, the position that they've been forced into, and I don't blame any of the exchanges for halting trading of XRP, because it's their businesses that are at stake. It's them, their families, their livelihood, their employees' families. Everyone there is at stake. And so them taking what they believe to be the most legally prudent path, I'm not going to fault them for it. I blame the SEC, and I don't think it's right for any of us to come down on the exchanges for making that decision. It's the SEC that we should be blaming, frankly. But the implications, my gosh, you guys are familiar with the library case, right? I'm not going to get into all the specifics in this video. That would be outside the scope of what I want to talk about. I've covered it thoroughly on this channel, but in case you're unaware, just to get you quickly caught up here, there's another cryptocurrency that's called Library Credit, LBC for short. And there's an entity called Library, which goes by LBRY for short, but it's pronounced library. And they're the ones that are running this operation. They've got a whole bunch of stuff going on, again, outside the scope of this video. But all you need to know is that the SEC is coming after them as well, with a lot of the same claims that we saw levied against Ripple, the company. And so Library shared a couple tweets here that I want to share with you, and then I actually retweeted that, and then Library wrote back to me as well. So I want to share with you the little bit of the back and forth here. It's highly fascinating. And it has to do with this idea of having a license to hop on the internet. No thank you. Anyway, so here's what Library wrote. In response to the SEC's persecution of Library, Bittrex is removing U.S. access to LBC. So pause right there. This is exactly what we saw happen with XRP. So this is not surprising, right? Bittrex is removing access to LBC for U.S. citizens. And then Library continues. 3 new Chinese exchanges are adding LBC. So look, not all bad, right? But they write the following. Why is the United States ceding the blockchain industry to the Chinese? In the late 1990s, there was a serious debate among politicians to require licenses to go online. This is what's at stake, but this time for blockchain. Will they make the same mistake 20 years later? And they share this little screen grab. And you can see here it was dated November 28th, 1999. And there's somebody named Bogatur. I don't know. It doesn't matter. This was pulled from a website. This is actually being considered and actually pushed by some people way back in the day. So here you go. And I don't know how to say these names, so I'll just do my best. But Robert Kallio, Cailliau, Kallio, nailed it. Anyway, Robert Kallio, who designed the web with Britain Tim Berners-Lee in late 1990, says all internet users should be licensed, so surfers on the information highway are as accountable as drivers on the road. Well, what a good argument. Everybody's got to be held. What, you don't want people to be held accountable like drivers on the road? But people could do anything on the internet. They could write anything on the internet. Oh my gosh, what are we going to do? And then a W3C, that's the World Wide Web Consortium. And by the way, the World Wide Web Consortium, they're certainly still around, and they're actually the reason that the Interledger Protocol, which was pushed by Ripple and created by Ripple employees along with others, that's actually been adopted. Interledger Protocol has been adopted in pretty much every major browser on the planet, including even Apple's Safari. So if you have an iPhone, it's on your phone right now, and that's thanks to the W3C. So they've got power. They've got the ability to push stuff through, right? And so the W3C, World Wide Web Consortium, has been working on such a system for years. And again, this is back to the little screen grab here, talking about requiring licenses to use the internet. The W3C has been working on such systems for years. Unforgeable certificates which users must present to gain access to content and which, incidentally, identify them uniquely and provide assorted marketing information. The end of anonymity coming soon to a web near you. So how about that? Is that the type of crap we want to see with crypto? Do we want to see everything just shut down? Because if you have sufficiently harsh regulation, you're just going to kill all the innovation and people just won't participate. And it's not that the innovation won't ever happen, it just won't happen here. So again, I don't think that we're going to have that type of doomsday scenario, but that is what's at stake. And so Attorney John Deaton is absolutely correct. He's completely killing it on that. And so then I retweeted that and I wrote the following. As many of us have been saying, it's not just Ripple and XRP that are in hot water. Let's not mince words. If you're a company in crypto operating in the United States, the government is coming for you. Petty ideological positions should be tossed. Let's unite. And Library saw that. I retweeted that and wrote the following. They used the little 100 emoji that's in red. They put down 3 of those and then wrote, "It's about users too. Eventually, they'll be coming for all users of crypto in the United States. There's nothing about the U.S. law that makes it apply only to U.S. companies. Under the standards being currently advanced, almost every crypto is a security." Exactly. So this is the same stuff we've been saying within the XRP community. It's going to affect everyone, and so Library clearly gets this. And it was interesting timing because I was actually reading this thread from John Deaton that I just shared with you before I came across these comments from Library, and so it was rather timely actually. And so I responded to them and I wrote the following. "This is absolutely correct. Attorney John Deaton wrote this rather informative thread highlighting that individual holders can be in trouble with the SEC for their own transactions if court proceedings don't go well." And so this is the world we're living in. Hopefully things don't go down the crapper. I'll wrap up there though. I am not a financial advisor. Do not buy or sell anything because of anything that I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.